Hello and welcome online. I'm Jean Orihana. Joining us at the ANC Center in Manila is the former Director General of the Philippine National Police and now a Senator of the Republic, Panfilo Lacson. Welcome back online, Mr. Senator, and thank you for giving us this opportunity.
Good evening, Jean. Pleasure to be here.
Mr. Senator, how are you now?
I'm okay. Surprisingly, I feel okay in spite of the recent decision rendered by the Supreme Court reversing the original decision that barred the reopening of the case, of the Kuratong Baleleng case.
Did you see it coming? I asked that question to find out how you felt about your case before the Supreme Court, how the arguments of your lawyers were it strong, were it convincing, were it based on legal grounds, for example. Were you confident?
I was so confident. I did not see it coming because the law is with us, no, in this particular case. And I suppose the Supreme Court was deciding on a question of law. And the law is very clear on the matter that when a new law, a new statute, a new rule is passed or approved, then it should always favor the accused rather than the state.
Yes.
In this particular decision, I was amazed at how the Supreme Court failed to honor the time-honored principle that any new statute passed must favor the accused, because it's clear in the decision penned by Justice Callejo that the state should also be favored. I agree with that. But if there's a conflict on who to favor, any lawyer, any student of law will tell you that it is always favorable to the accused. And it is not only a practice here in our country. It is a time-honored practice internationally. So I felt so confident, and I was surprised even so when I read the decision.
Justice Secretary Simeon Datumanong, when I interviewed him on Thursday, Attorney Leonard de Vera, one of the private lawyers working for the reopening of this Kuratong Baleleng case, said that you are correct on that point, that any law should be applied retroactively if it is beneficial to a party or an agreed party.
I'm glad to hear that.
Yeah, they agree with that position of yours, but what they are saying is that there are two conditions that should have been fulfilled in the Rule 117 on the dismissal of a case after 2 years. And that is, your lawyers failed to file a motion to dismiss before the Quezon City Regional Trial Court a consent to dismiss the case provisionally or temporarily and to inform the relatives of the victims. That is their argument.
That is a question of fact. The Supreme Court always decides on a question of law.
Right.
And it is up to the Regional Trial Court, Branch 81. That's why in its original decision, they remanded it to the RTC. Branch 81 to determine whether the requirements to come up with a provisional dismissal of a case were fulfilled. But it did not come to that point because they disregarded, or that was set aside. It was overtaken by events, by developments, because while waiting for the Regional Trial Court to submit its findings to the Supreme Court that they fulfilled the requirements or they did not fulfill the requirements, they already rendered an adverse decision. This time, using the prescriptive period as the question at hand.
But did your lawyers or your group filed those petitions before the Quezon City Trial Court in order to satisfy that requirement of law?
Yes, they were properly notified through the public prosecutor, who was representing the victims or the complainants.
Yes.
And they were even represented by a private prosecutor who was present when, and even testified on behalf of the clients that they were amenable to the provisional dismissal. We were also notified and we gave our consent to the provisional dismissal. While it is true, or it may be true, I'm not sure if we filed a motion to dismiss, but we filed a motion for judicial determination of probable cause as a matter of course, because the judge, once an information is filed by the prosecutor, will still determine probable cause. Under the old law, under the old procedure, whatever is contained in the information filed by the DOJ, the judge has no say anymore but to adopt the information or the recommendation of the prosecutor. But there's a new rule that apart from the probable cause as established by the prosecutor, the judge will still have to render a decision if there's probable cause. We call it the judicial determination of probable cause. And it was all, everything was met.
What they are saying now, I'm talking here of government lawyers and Attorney Leonard De Vera, that motion for judicial determination was intended for the issuance of a warrant of arrest, but not a consent as required by the revised rules of court under section 711.
117.
117, yes.
No, when we file when when a lawyer files a motion for judicial determination, it's not only for purposes of the issuance of warrants of arrest, but to determine probable cause. Because if there is no probable cause, it is incumbent upon the judge to dismiss the case. And why fault the respondents in this particular case when the state failed to present new evidence within the prescriptive period of 2 years? We must remember, Jean, that this was dismissed in March 31, 1999.
Yes, by Judge Agnier.
By Judge Agnier. And at the time, the provision on the fixed prescriptive period of 2 years was not yet a rule.
Yes, it came out
December 1, 2000. So I was amazed at the decision penned by Justice Callejo that the prescriptive period countdown should start on December 1, 2000, not on the date that the case was dismissed by Judge Agnier on March 31, 1999. This is the first time. I'm not a lawyer, but I have a few units of law in college and in the PMA. And any student of law will tell you, I have asked around. I've asked so many lawyers. Every lawyer I meet after I read the decision, I ask them, I ask their opinion. There are one in saying that there's really a flaw in that decision. And I'm glad that lawyers in this country,
Attorney De Vera, Justice Secretary,
yes, even lawyers representing, but if they will go to the extent of questioning the facts, no, because we all know that the Supreme Court only acts on a question of law or decides on a question of law, never on a question of fact.
I leave that to the lawyers, Mr.
Yes,
Senator. Now, have you filed your motion for reconsideration? Because you have until April 16 or 15 days after that decision was issued on April 1.
No, the countdown will start or will begin once we receive a copy of the decision.
Have you
As of now,
received that?
we have not received a copy of the decision.
But you are working on your arguments for this motion.
Oh yes, definitely. I've consulted with my lawyer, and there are more lawyers offering to assist us legally in this regard.
At the height of another controversy which you faced before the Senate when you were accused of being behind drug trafficking in this country, you did not take a leave of absence from your position. Now, there are calls, particularly coming from the lawyers of the Kuratong Baleleng victims' relatives, that you should take a leave of absence. How do you take that suggestion?
And I did the right thing because after all, Ador Mawana just came out and stated categorically that every accusation that he made and further corroborated by other witnesses, planted by ISAF, not planted by this representation, he has already recanted. And if I took a leave of absence at the time, then that decision would have been wrong.
So you're not taking a leave of absence, even if this case is reopened before the Quezon City Regional Traffic Court?
If this case is reopened and it is physically possible for me to attend sessions, to attend to my duties as senator, then I'm not taking a leave of absence. But if it is physically impossible, then I cannot do anything about it.
You are talking here of a possibility that you will go to jail during the trial because this is a non-bailable offense, a capital offense. But how do you take that possibility that you would be committed to a jail while the trial is going on? Have you prepared for that possibility?
It has not entered my mind, Jean, that I would reach that point that I would go to jail on this particular case. We must remember, Jean, that when this case was originally filed, I was an accessory. I was not the principal. Now they are reviving an old case. Why then
a principal?
Yes, then it is still up to the judge to act on the motion, and the prosecution should file a motion to upgrade several respondents from accessory to principal. It is not automatic that we would be principals in this particular case.
Do you dread that possibility, being together with people that you have arrested before or people that you have fought before as chief of the Philippine National Police?
I have not entertained the thought, Jin.
Why, sir?
I refuse to entertain that thought, you know.
That means that you are confident that you can still turn around this case in your favor. Is that it?
Oh, yes, because when I read the decision, you know, while I was somewhat disgusted with the decision, but somehow I see a window of opportunity. That's why we are preparing our motion for reconsideration, hoping that we will be able to enlighten the justices of the Supreme Court to see the light in the law.
Yes.
Because it is very clear. Well, as you said earlier, even the DOJ secretary, no less, agreed with my position that any law passed, any new law passed, should retroact in favor of the accused.
Right, yeah.
And this is no different from other cases that were given the same treatment before.
A day after the Supreme Court issued that decision on this question, you were quoted as saying that, but as things stand now, there is a very slim chance that our motion will be granted. Was that a statement out of frustration at the time when you got the decision or read the decision in the media, or now your position or your confidence has a bit changed now?
Actually, I don't remember issuing that statement, but if it really came from me, then maybe it was out of frustration.
Out of frustration.
Yes.
On the matter of statements being attributed to you, because in Malacanang, they are saying that your declaration of running in 2004 was made in order to put politics into the issue.
Yes.
That you preempted the decision of the Supreme Court and intended that declaration of yours to gather sympathy from the public.
Jen, it defies logic. If I had contacts with the Supreme Court, I wouldn't have lost the decision. Remember, it came from 13-0.
Yes.
That was the count when it was originally decided upon. So if that was the premise, then
you knew that the decision would be coming against you. That's why you declared that you would be a candidate for president in 2004. Then that's it.
If that's the premise, then it presupposes that I had contacts in the Supreme Court. If I had contacts, then there's no way I could lose. So, no, I don't, there's no truth to that.
That statement or that observation by Malacanang and officials there was prompted by another statement which was issued before you announced your intention to run for president. A statement which came out in the media on March 31. Although you have denied this.
Yes, I haven't.
You were quoted as saying here that Malacanang was, quote, bent on having opposition presidential bet Senator Panfilo Lacson jailed, unquote, over the multiple murder case. This was the first statement.
There were press statements issued by my camp, no?
Yes, your publicists.
By my publicists.
Yes.
And it
could have been.
Yes, it doesn't necessarily. It had not come from me.
But you are, or do you believe that this reopening of the Kuratong Baleleng multiple murder case was a part, or is a part of efforts to scuttle your presidential bid?
As things were developing, no, the resurfacing of Ador Mawanay, pointing to the first gentleman as the architect after Corpus withdrew him from the witness protection program or released him from the custody of ISAF.
Yes.
No. Then, and the first gentleman did not deny that he really sent a text message to that number that Ador Mawanay has in his possession.
Yes.
And this, even the reporters, when they counter-checked, no, it was Mike Arroyo who answered. That same number as shown by Ador Mawanay na nag-send sa kanya ng text. But I was surprised, you know, how could he go so low if, assuming that the allegations now of Ador Mawanay were correct and true, no, then there's too much insatiability. Imagine attempting to transfer money, funds from imagined bank accounts to be transferred to his own bank accounts. That's the height of insatiability, Jin.
You question the credibility of Ador Mawanay
yes,
then?
up to now.
And up to now,
yes.
But you're kind of consoled or happy that he is saying this in your favor, all these allegations in your favor, and hitting the first gentleman, Jose Miguel Arroyo.
All the time, all this time I was maintaining that I don't know Ador Mawanay. No? I had not met him except on one occasion when he was in the gallery. I was questioning Victor Corpus. Remember, during the entire proceedings, during the Senate hearings, I attended the hearing only once because I was trying to avoid coming face to face with Ador Mawanay.
Yes.
Because, you know, some character like him, face to face, lying through his teeth, and he would be there in front of you. Eh, sabi ko nga nun, baka hindi ako makatiis, tumayo ako dun sa panel seat, go to his back, side, eh baka mapatukan ko. So, I made it a point not to really have a face-to-face confrontation. But when Victor Corpus was about to testify, I made it a point too that I would be there to question him. And I noticed a guy, a character, you know, resembling Ador Mawanay in the gallery. And he was looking at me. He was staring at me. That was the first and only time that I saw the person.
Now that Ador Mawanay has made a 360 turnaround,
720.
720 in your case, on his allegations before Mary Ong, your nemesis, is saying that Ador Mawanay is a plant of yours in this controversy.
Again, Jean, no person in his right senses, no sane person would plant a witness to destroy him for so many months. Remember, ilang months ako nagsuffer sa mga lies ni Mawanay, corroborated by another liar, Mary Ong, that's Rosbud. Because if the principal witness who is testifying is a liar, then necessarily the person who corroborates his testimonies is a liar. It only follows.
These developments now, as you have pointed out, may be...
It only follows.
These developments now, as you have pointed out, may be about politics. But what is at stake here is your innocence.
Oh, yes.
Now, you have been quoted as saying, or, well, implicating doubts on the probity and integrity of the country's judicial system. But here you are fighting for your innocence before the same system that, based on reports, you have criticized.
No.
You have never.
I have never. Maybe
the statements again. Yes.
Statements as released.
May I quote that, Mr. Senator? Based on the statement in the media attributed to you, quote, the decision of the High Tribunal bodes ill for the rule of law in this country, considering that the same Supreme Court defined the rules of prescription, reversing itself today even without the benefit of new arguments, with 7 of the Supreme Court justices who voted earlier for the 13-0 ruling reversing themselves, leaves a lot to speculation, end quote.
This statement directly attributed to me. No, ang sabi ko doon, I still believe in the judicial system, and that's the reason why I am filing a motion for reconsideration. Because if I didn't believe anymore the criminal justice system or the judicial system, hindi na ako magpa-file ng motion for reconsideration. Right. I'm out of here.
You're out of here, meaning?
Well, if you don't believe in the system, you get out of the system. And the fact that I'm still here, I'm exhausting all legal remedies.
Yes.
That's a testimony that I still believe in the system.
By saying
it's only a matter of enlightening the Supreme Court justices.
You have a wagon, maybe, or a basket full of recourse in this case.
Yes,
you can
definitely
file so many arguments before the Supreme Court and the regional trial court. So this will drag on. This will not be resolved by the time that you would be campaigning in 2004 for the presidency.
I would want to take it one step at a time, because right now we're facing still the Supreme Court, and I'm confident that we can overturn the 10-4-1 decision. Well, we came from 13-0.
Yes.
So there's no reason why I shouldn't be confident that, especially so that the argument or the decision used that particular line of reasoning, yung prescriptive period. So that makes me all the more confident.
Can you still sleep with that possibility that you would be jailed and convicted?
Well, I sleep at night. I sleep in the car because I used to I go around, because I have accepted invitations for commencement exercises, and every day we're out there in the provinces. I came from Palawan, from Masbate, Lawag, Batangas. This morning I came from Bulacan. So it's a normal, activity.
You announced your candidacy or your intention to run for president in Lawag City on a weekend. Why such a low-profile announcement, no fanfare of sorts?
No, I was asked by a reporter.
Okay.
And he didn't give me a choice to, expound on my intention. Ang sabi niya lang sa akin, sir, pwede bang yes or no lang ang sagot? Are you running?
Okay. So
And
you answered yes.
Oh, yes. And then I qualified.
How did you qualify that?
Right now in the
response?
opposition, Senator Angara has already declared that he has withdrawn from the race during the FOCAP meeting which he attended. Of course, Fernando Po Jr. Up to now has not been convinced by no less than former President Estrada to throw his hat into the political derby. And I had a luncheon meeting with Ambassador Cojuangco.
Yes.
And, he also indicated that he's not interested. So I told him that in answer to that question, since no one is left standing in the opposition, so I might as well answer yes.
I don't know if you have read.
It was not a declaration of candidacy.
It was in response to a question.
Yes.
I don't know if you have read a statement in reaction to that report of your interest in running, quoting Crispin Remulla, sort of saying, not too fast, Junior. Because the opposition has not yet picked its standard bearer for the 2004 presidential elections.
That's correct. No? The United Opposition has agreed to field only one standard bearer. And up to now, there is no official announcement or declaration as to who should be the standard bearer. But PMP, the Partido ng Masang Pilipino, yung party ni former President Erap,
yes,
has already adopted me as their guest presidential candidate. No, as a matter of fact, the former Secretary of DAR, Secretary Morales, the president now of PNP, is with the team, no? Lito Banayo and the other former cabinet members of the former president are with me.
What you have said and what you have declared can be interpreted as something like you are offering yourself to be,
in a manner of saying, yes,
standard bearer of the opposition. But if you are not picked as the standard bearer, then you would go for the majority in the opposition, for example.
Oh yes, I'll go back to the Senate and finish my term up to 2007, and that's it.
You're just saying that you are available, that you are interested.
Yes.
Mr. Senator, we have to take a pause.
Okay.
Online returns with more questions and the answers from Senator Panfilo Lacson. You are still online. I'm Jean Orejana at the ABS-CBN News Channel Center in Manila. We are trying to go beyond the headlines and hear more than the sound bites to the issue of the day from the former Director General of the Philippine National Police and now a Senator of the Republic, Panfilo Lacson. Mr. Senator, government lawyers are saying that they have an airtight case against you and the other policemen accused in this Kuratong Baleleng multiple murder case. They have new witnesses who would be presented when this trial reopens soon.
Then they might as well wait for the remanding of the case to the RTC and present their case, their evidence. No? Instead of, talking about airtight case, new witnesses, strong evidence.
Yes.
They should wait for the trial to start before they should offer this evidence.
How do you respond to comments that the dismissal of the case in 1999 was based on mere technicality but not on the merits of the accusations against you and the other members of the defunct Task Force Habagat of the Presidential Anti-Crime Commission?
Maybe so, but that's the procedure, that's the law. We observed due process. It was provisionally dismissed because at that time there were no witnesses. The evidence was weak, and that's the reason why they were given ample time to look for witnesses, to look for new pieces of evidence for them to present. But the idleness or the inability of government to look for new evidence, new witnesses, and to make their case stronger, is not the fault of the respondents. They were given 2 years.
This question had been asked of you and still being asked by the public, that the outcome of that case was because you work for it. You work for the disappearance of the witnesses, you threatened witnesses, and all those things.
No, we didn't threaten the witnesses. They went, or at least one of them, went out of the country on his own volition.
Reyes.
Reyes.
To Canada.
We had no hand in his decision to go to Canada, because at the time he was under the Witness Protection Program.
Yes.
So somebody in government must have assisted him to get out of the country.
But would you rather have this case resolved on the merits in order for you to, well, prove your innocence once and for all?
Whatever it may be, it should, you know, ang punto namin dito is to get over with this case, this problem, because it's been 8 years, no? It's been haunting us. And whatever it takes na ma-acquit kami dito or matapos yung kaso, we'll go for it.
8 years.
After all, this is our life, this is our future, and this is our freedom, our liberty.
How about public opinion? Have you looked into what people think about this case? Because again, if you gather an informal slice of public, pulse of the public, they would say that it's true, the charges are true.
Well, that's too premature, because we have not tackled the merits of the case in court, no? And when we talk to people, especially victims of bank robberies, victims of crimes, no, I think public opinion is all for us. Sino ba itong mga tao na ito? Ito yung mga tao na pumapatay indiscriminately when they were making their heists, ano, kinagko-conduct sila ng mga bank robberies. Indiscriminately, they fired upon innocent civilians, bystanders. No? I remember seeing in one early evening news, ano, watching an old woman profusely crying, no, because her only daughter just finished the nursing school.
Yes.
Ang sabi niya, ito lang yung pagkakataon para matulungan na ako ng anak ko. Natayo lang doon sa tapat ng Bangko de Oro, doon sa malapit sa SM, sa Santa Mesa, napatay ng mga, hindi pa namin alam na Kuratong Baleleng. When I saw that woman, no, it really touched me. And I made a vow. Sabi ko, intensify namin intelligence gathering. I would say to you that I will render justice, or I would render justice to that old woman and to the daughter. No. And it, you know, it intensified my resolve to really get to the bottom of whoever was responsible for that bank robbery in Santa Mesa. There were countless policemen, countless security guards, bank tellers who were victimized by this group. And yet, there were so many cases involving, you know, non-criminals, hindi katulad nitong mga tao na ito, na hindi naman binibigyan ng pansin ng gobyerno. And yet, just because I'm one of the principal characters in this case, masyado yung interest ng gobyerno. Thousands upon thousands of cases yung na-provisionally dismissed, even in the absence of Section 8, Rule 117. It was incumbent then upon the judge or the judges to determine kung ano yung period within which they could already declare the case as permanently dismissed. Wala naman nagko-question eh. Hindi lang naman ito yung kaso na provisionally dismissed pagkatapos na na-revive. Ito lang yung na-revive. But then, ang daming naging permanent and dismissal. Even without the formal rule, no, na Supreme Court pa yung nag-deliberate dito. And kung pag-uusapan yung intent, yung intention nung binalangkas yung bagong rule on the revised rule on criminal procedure, ang intention talaga is to cover yung past cases. So yung mga respondents, yung mga akusado, mawala na yung sword of Damocles hanging over their heads. Yun ang intention. So to say now that it should apply prospectively and not retroactively, I think is a wrong interpretation of the revised rule on criminal procedure, yung Section 8, Rule 117.
Based on that, you are saying that you are being persecuted by the Macapagal Arroyo administration.
Kasi dapat kung hindi sila nagpo-prosecute, ang tinignan sana nila yung mga iba pang kaso na tulad yan. When I ran as senator, I can still remember, I lost 2 weeks, from May 1 hanggang about May 14 yata yun, hiding. I was immobilized practically. I could not campaign kasi nag-declare ng state of rebellion
and
warrantless arrests were issued against me, against Senator Honasan, who was also then a candidate for senator. So nasa yung hindi pa persecution yun. And then when they perceived or when they learned that the Supreme Court would come out, because we filed a petition questioning the state of rebellion and the warrantless arrest as issued. When they sensed that lalabas yung Supreme Court decision favoring us as petitioners, they lifted. It's a good thing that they lifted because it was timed when we were about to hold our meeting de avance in Cuneta Astrodome.
Would you hide again if this case reopens and a warrant of arrest would be issued for you to be jailed?
It depends. I told you, Jean, earlier na I still believe in the criminal justice system. I continue to believe in the judicial justice system.
But would that be an option?
That will be an option.
That will be an option.
Yes.
And that would make
hanggang naniniwala tayo sa criminal justice system. Kasi if you don't believe anymore in the system, what's the use of placing yourself within that system?
But as an officer, then police general, and now gentleman at the Senate of the Republic, how would that now impact on your being an officer? And
I would like to reiterate again, I still believe in the system. I will continue to believe in the system. If I cease to believe in the system, maybe that option could be a choice.
The comments and the questions now, Mr. Senator Jeffrey De Leon Jr., online from Capiz. Senator, how about Davao City Mayor Rodrigo Duterte, your Vice President?
Well, alam mo, ang daming problema sa Davao ngayon, and I don't think Mayor Duterte, si Rudy, would have time to think about politics, to think about 2004.
But are you considering him?
Yes, he's a good man. He's for peace and order. No, he's a tough executive. So
you see eye to eye when it comes to the fight against criminality. An eye for an eye, tooth for a tooth policy. Jam Navales, online from Taguig, I believe there's no need for Senator Lacson to go on leave since he's a mere accessory to the case. Perry Bakalan, online from Makati, no, in response to the question online, should you take a leave of absence? Politically motivated yung action nila. EDSA, online from Baguio City, go on leave, Senator Lacson, your sins will find you out. That's the comment. Ariel Lescano, online from Lipa City, Lacson, once and for all should face his accuser so that truth will come out, and for delicadeza, he should take a leave of absence. Well, it's a mix.
Well taken.
WML, online from Quezon City, take a leave like what Perez did when he was embroiled in a controversy. Doming, online from Quezon City, why should Senator Lacson go on leave? In fact, that case has been closed. It's unfair to revive cases for political reasons. Ryan Remigio, online from Lawag City, Senator Lacson, don't worry because they can never put a good man down. Jason, online from Quezon City,